Underwriting for the Money Doctor Show is provided by Ryan and Casey Liquors, Main Street, Greenfield. Exploring the world, one glass at a time. West County Equipment Rental of Shelburne. Daily, weekly, monthly rentals. 625-6463 or on the web at westcountyequipment.com. The Franklin County Community Development Corporation. Growing sustainable businesses and communities since 1979. www.fccdc.org. Weld Communications, Marketing and Publicity. Helping businesses spread the word in the Pioneer Valley and beyond. www.weldwords.com.
There's a better life if I could be debt-free, but all my money is a mystery. I was feeling overwhelmed and it was wearing thin when I knocked on the door and heard the doctor's in. Oh, the doctor's in, the doctor's in. She got the right prescription to help you win. Oh, the doctor's in, the money doctor's in.
Hello and welcome to the Money Doctor Show. I'm Dr. Frances Rayam, president of Power Down Debt, a positive debt management company. And my guest today is attorney Steve Weiss from Shatz, Schwartz, and Fentin.
You got it right.
I'm so glad I don't have to answer your phone. That would be incredible to say that all day long. So welcome.
Thank you.
Thanks for being
Pleasure to be here.
Oh, my pleasure. All right, so we should start off by saying the reason I asked you to be here rather than any other attorney that I know is that somehow, despite the fact that you're a bankruptcy attorney, it manages to be fun. I don't know if we could say fun, we can stretch that a little bit. But
yeah, I don't know if it's fun.
You have an upbeat personality.
It's interesting to me, and I don't know if I'd call it fun for the people that are going through it at the time.
Oh, it's definitely not fun for somebody.
But it is interesting, and it's important. People, it's unfortunately a reality of life, and has been since colonial times. The bankruptcy is mentioned in the Constitution. It's just there, and especially when I'm representing people in personal bankruptcies, I try to at least kind of help them understand the process and work their way through it.
Well, certainly, I mean, we both deal with people with financial troubles and whatnot. Bankruptcy is never fun for anybody. Having an attorney that is doom and gloom is even worse, I think, because you're already struggling to go through this. Tell me a little bit about how you ended up being a bankruptcy attorney rather than some other area of practice.
Well, it was sort of serendipity, actually. I was in my third year of law school. I was still looking for a job, and a bankruptcy judge in Michigan was looking for a law clerk. Came back to the law school that I went to Boston University for law school. I interviewed with him, and because I went to Michigan State for part of my undergrad education, I actually knew where Bay City, Michigan was. We hit it off, so I clerked for a bankruptcy judge in Michigan for 2 years, which was just a great training ground. It was an apprenticeship. I learned not just what impresses judges, but also what doesn't impress judges, and I really learned that part of the practice. And then I was coming back to Massachusetts, and my wife and I were coming back this way, and I had a specialty, and I ended up working as a bankruptcy attorney, and it's been 26 years of doing that now.
And so, have you been with Shatz, Schwartz, and Fentin for 26 years?
No, I joined a different firm in 1986 when I first came here, and then in 1994 I joined Shatz, Schwartz, and I've been here for almost 20 years now.
And you can say it. I love that.
Well, if you say it often enough, it gets easy.
So you're in Springfield, Mass.
Yes.
Which is a little bit out of our area, but
yeah. Well, we also have an office that we use in Northampton as well, and sometimes I do come up to Northampton to meet with clients.
Yeah, and there are cases that I see at Power Down Debt. Very few people that come to us are candidates or should be candidates for bankruptcy, in our opinion. But when they are, you're one of the attorneys that I recommend. I will usually give them a few different names and say, see any attorney you want, but call this guy, he's good. And it's in part because you're a trustee. So will you tell us a little bit about being a trustee in Hampshire and Hampden County?
I'm a trustee for the 3-county area, Hampden, Hampshire, and Franklin.
And Franklin, okay.
There are 4 trustees in the area. I'm one of the 4. Okay. And being a trustee is an administrative position. My job as a Chapter 7 trustee, I'm appointed by the Department of Justice, and I get roughly 1 out of 4 Chapter 7 cases that are filed in this area. And my job is to administer the case, which means to examine the people that are filing for bankruptcy relief, to determine if there are any non-exempt assets that I can liquidate and recover money for creditors, to actually liquidate those assets in any way that I can see fit, I mean, with court approval,
right.
And then ultimately to distribute the money to creditors under the priorities set forth in the Bankruptcy Code. Administrative claims get paid first, alimony and support claims, then tax claims, wage claims, and those sorts of things, and then eventually to unsecured creditors.
Okay. Now, thank you for that. Let's dumb it down to English for me a little bit. You're a person who's about to file a bankruptcy, or you're thinking about whether is bankruptcy a good choice for you or not. What would you say to somebody who's considering that? I mean, would you ask them, are they very delinquent? Do they have another way out? How do you decide who's a good candidate for bankruptcy?
Well, I try to, the way I talk about it with clients is that what I do in a first meeting, it's like medical triage, only it's economic triage. The first thing I try to do is find out whether there's really a crisis. For instance, I have literally had people call me up on a Tuesday morning, and I ask them when the foreclosure auction is scheduled, and they say Wednesday morning.
Right.
At that point, they have no choice, if they want to save the house, but to file a bankruptcy petition.
Because it stays the foreclosure.
Correct. Right. And then there are times where once I ask a few questions, not only will a bankruptcy not do them any good, it would actually be the wrong thing to do for them.
Important.
Like when I find out that mom's house is in their name.
Right, right.
That's a reason not to file a bankruptcy petition. And then everything else, I think it's a spectrum. What are their income and expenses? How much is their secured debt if they own a house or a car? How far in arrears are they? What sort of credit card debt or other debt, alimony, that type of thing. And then ultimately, what are their desires? Do they want to keep the house? Do they want, or have they decided they simply can't afford it under any circumstances anymore? Because it's ultimately their decision.
Right.
My job is to try to get as much information as I can from them so that I can then give them the best advice about what they want to do. And that's kind of how I see the process. Okay.
So just for anybody who doesn't know out there, a secured debt is a debt that is secured, in fact, is attached to a house or a car or something, some form of collateral.
Right.
So an unsecured debt, a good example would be a credit card.
Yeah.
If you default on your credit card, they can't take your house. It's not secured by your house. It's a credit card.
That's correct.
So bankruptcy typically wipes out unsecured debt for the most part?
It typically wipes out all unsecured debt with a few exceptions. Okay. One is debts that are incurred under what I'll call bad circumstances, fraud, embezzlement, Bernie Madoff kind of stuff.
Right.
Those debts are not discharged. Alimony and child support are not discharged. Most tax debts are not discharged up to a certain period of time. Student loans are not discharged unless you can show that there's an undue hardship.
Yeah, we'll come back to that.
And we'll get back to that, I know. But other unsecured debts generally are discharged. Credit card debts, medical bills, and those sorts of things are generally discharged in bankruptcy.
Okay. So now, very often I don't talk anything about my business on the show because it's not really about that. But because our businesses overlap a little bit in that area, I would say that what happens for people who come to see us when bankruptcy might be an option, but it doesn't solve all their problems, is I want them to do like a two-prong approach. I want them to file a bankruptcy to wipe out all the unsecured debt that is killing them, that they cannot pay. And then I want them to come and do power down debt for all the stuff that's left over, like the house, the car, and the student loans, whatever's left over, so that they not only get that debt paid off quickly, but they get the financial counseling going forward. So I said all that to ask you this. How many times have you seen or heard of somebody who has filed bankruptcy more than once?
A number of times, actually. It used to be, and it's actually sort of interesting now, because it used to be that a person could file a bankruptcy petition once every 6 years. In 2005, the bankruptcy code was changed so that it was once every 8 years. Well, that 8-year deadline is coming up in October of this year, October 2013, and there is speculation that there are a lot of people who filed a bankruptcy petition under the old bankruptcy code before October 17th, 2005, who come October 17th, 2013 will now be eligible to file again, and there's going to be a bump in bankruptcy cases.
I can tell you that I talked to a local banker who is concerned about that.
Yeah, it does not surprise me.
Yeah, and the FHA with the mortgages and all of that sort of thing, all entering into that. How often can somebody file a bankruptcy, and what can they wipe out, and can they do it again and again and again? And there can be professional bankruptcy people, apparently, who just build up debt and then wipe it out 8 years from now. I mean,
well, I don't know if it's professional people, and I think there was a misconception, or there is a misconception, that people just think about filing bankruptcy as a positive thing or as a strategy. I don't think anybody wakes up in the morning. I don't think people wake up in the morning and say, this just feels like a good day to go bankrupt.
Right.
I think what's more likely is that people, when they're making money, can pay their debts, and then when something in their lives happens, it becomes much harder. When I clerked in Michigan, one of the things I saw there is that a great many of the people in bankruptcy were in the auto industry. And when the auto workers were making money, they were making good money.
Right.
And they were buying boats, and they were buying RVs, and they might have a camp up in northern Michigan. And then when they got laid off, as typically happened, or they got hurt, which as typically happened, now they couldn't afford those all of those debts,
right.
And they ended up in bankruptcy, and some of them 3 or 4 or 5 times over the course of their lives.
Right.
But I don't think it was intentional. I think it was just because their income was ultimately not very stable.
If you've just tuned in, my guest today is attorney Steve Weiss. We're talking about bankruptcy, maybe in a different light than you would expect. That leads me to another question that I was thinking of. Let's bust some myths about bankruptcy. People will call me and they'll say, well, I don't want to file a bankruptcy because I'm going to lose my house. Myth number 1, what do you think?
The short answer is not true, as long as you can continue to make the payments on the house. The banks, mortgage lenders are much more interested in getting your money than they are in getting the houses. The bankruptcy code says that with a secured debt, like a mortgage debt, you have to do a debtor has to do one of 3 things: either surrender the property, which most people don't want to do, but some do, to redeem the debt, which means to pay off the amount of the mortgage loan at that time, and that's not practical for obvious reasons. And the third is to reaffirm, which essentially takes that debt out of the bankruptcy. There's a reaffirmation agreement that's signed that says, I'm going to keep making the payments. The bank still has its mortgage on the property, and if I were to default in the future, and if there were to be a foreclosure, and if there were to be a deficiency, the bank could still collect that deficiency. But in most cases, when people once they can get rid of all the unsecured debt in one way or another, they can usually afford to keep the house.
Right. That's my point exactly.
Yeah.
Good. Okay, we have a few minutes left before the break, so let's talk a little bit about student loans, because that is a big thing. I hear people, we do a lot with student loans, which most debt companies don't do. But people are coming out of school with $100,000, $150,000, $200,000 in student loans. And my experience is they often don't have any idea what it's going to take to pay those back. They know it's going to be expensive and they know it's going to be scary, but I see people with $800, $900 a month in student loans, and they can't afford to start the practice they wanted or buy the house they wanted because they're busy paying back their student loans. What do you say to somebody who says, why can't I file a bankruptcy on my student loans?
Well, the short answer again, and I'm not great at short answers,
but
the bankruptcy code says that student loans are non-dischargeable unless you can show that it would be an undue hardship not to discharge them. And what an undue hardship is very fact intensive. On the one hand, if you're talking about a 25-year-old who, let's say, got an MBA and then decided to become an artist or make pottery,
right.
That's not an undue hardship. That's a lifestyle choice. On the other hand, if you're talking about somebody who went back to school as an adult, I've had several clients over the years who have gone back and gotten doctorate degrees, and they're 50 years old or so. They come out of school with $150,000 or $200,000 in student loans, and then they are beset by health problems and they can't work full time. Well, that may be an undue hardship, but it's really fact determined, very fact specific.
And I would imagine difficult to prove.
Yes, and it's a debtor's burden to prove that. The debt is not dischargeable unless you can show that it would be an undue hardship. So you have to show not only that it's a hardship now, but that it's not going to change in the future, which is why younger people have a hard time showing that. If someone's coming if they're a few years out of law school, let's say, and they're making, I don't know, $60,000 a year, a judge might surmise that they might be making twice that in 5 or 10 years and be able to pay the student loans.
Right.
So it's really a forward-looking type of analysis, which makes it very difficult.
Interesting. I'm going to take a break there for a minute. When we come back, I'd love to ask you about some bankruptcy stories. Will you share some stories with us?
I'll be glad to.
All right. We'll be back in a moment.
Underwriting for the Money Doctor Show is provided by Ryan and Casey Liquors, Main Street, Greenfield. Exploring the world, one glass at a time. West County Equipment Rental of Shelburne. Daily, weekly, monthly rentals. 625-6463 or on the web at westcountyequipment.com. The Franklin County Community Development Corporation. Growing sustainable businesses and communities since 1979. www.fccdc. Weld Communications, Marketing and Publicity. Helping businesses spread the word in the Pioneer Valley and beyond. www.weldwords.com.
Welcome back to the Money Doctor Show. I'm Frances Rayam. My guest today is attorney Steve Weiss from Shatz, Schwartz, and Fentin, which I have to say slowly, but welcome back.
Thank you.
Thanks. So on the break, we were talking a little bit about stories, and I opened the show by saying, you know, you make bankruptcy fun. Maybe not to the people who are filing the bankruptcy, but somehow when we have conversations, there are always some good stories that come out. Tell me the first thing that comes to mind when I say to you, have you ever had a funny bankruptcy case?
There have been a lot of funny incidents. Most of them I probably can't mention on air.
Yeah, I knew you would say that.
But some of them have a sense of, you have to have a sense of humor in this practice, and sometimes things can be absurd. It's the only way to put it.
Can you give an example without selling anybody out? I know it's difficult in your profession.
Yeah, well, just sometimes I've had answers when I'm examining a debtor at a meeting of creditors, and I ask, "Well, do you own any real estate?" And the borrower and the debtor says, "Well, you don't mean that thing I have with my mom, do you?"
Oh no! Right.
Or I had a case where I asked somebody, "Well, are you suing anybody where you think that somebody might owe you money?" And the debtor looks at me and goes, "Yeah, but my other attorney is handling that." And his bankruptcy attorney looks at him sideways and goes, "What do you mean, other attorney?"
Other attorney, right.
And it turns out the guy was suing. He was suing his employer for $750,000.
And trying to file a bankruptcy.
Yeah,
and of course, the problem is if that money came in,
it would pay creditors in full.
Exactly.
And I eventually settled the claim for a lot less than that.
Yeah.
But when you ask about absurd or interesting moments, those come to mind.
Now that brings up a question, because earlier we talked about the fact that you're a trustee in Massachusetts. There's no conflict of interest? I mean, they have to get attorneys to be trustees, right? How do you manage both sides of that?
Well, most trustees across the country are attorneys, although not all of them.
Okay.
And obviously, I can't be a trustee in the case where I'm representing somebody, and that's why there's 4 trustees in the area. So part of my practice is being a bankruptcy trustee. Yep. Part of my practice is representing debtors or borrowers, both consumer and business. Part of my practice is representing lenders and creditors on occasion. Yep. And I can't do both in the same case. Right. But I actually think it helps that I, for lack of a better way of putting it, work both sides of the street, because as a trustee, when I'm representing a debtor or a borrower, I kind of had to have an insight into how I think the trustee is going to analyze a case. That's
why I said when I recommend you, it's in part because I know you are a trustee. I know you have that experience on the other side, and you know what somebody is expecting to see. We talked about stories a little bit. I said I would come back, we'd talk about some stories. We were talking about, give me an example of somebody's got a bankruptcy at hand, and they've got some real estate and they've got some other things. They don't think they have a lot of money, but they happen to have some, I don't know, antiques on the side. How does that get valued? What happens with that?
Well, the first thing is that when someone comes into bankruptcy court, they're allowed to exempt certain types of assets and certain values of assets. Mm-hmm. And the majority of bankruptcies are no-asset bankruptcies, meaning that there are no assets that have any value in excess of those exemptions. But occasionally people have assets that do have more value. It may be a partial interest in real estate. It can be jewelry or collectibles.
What about, Harley Davidson motorcycles and I don't know,
antique cars.
Vehicles, antique cars, and horses, or
I had a case where I've had cases where, when you talk about some of the stuff that gets sort of interesting, a case where the debtor had a 1/2 interest in a racehorse.
Right, exactly. I was happy to say horses, right.
Yeah, or 1/2 interest in a racing greyhound.
Good racehorse? We don't know.
No.
Okay.
But I had to figure out how to value it, and that's one of the tricks, or one of the tricks, and also one of the interesting things about being a trustee is trying to figure out how to value an asset. Now, cars, Harley Davidsons, antique cars are for the most part, those are relatively easy, because whether you go to kbb.com or whether you go on the internet or you go on eBay, you can figure out values of some things.
Pretty close, yeah.
Artwork is an interesting question. How do you really value artwork? I had a case once years ago where I was selling I think it was about 75 paintings that had been part of a collection. I ultimately hired an art dealer to sell those. But what I try to do, and valuing lawsuits, what's the value of a lawsuit? That's really tricky.
Right, because it hasn't happened. You don't know if you're going to win. I mean,
well, you have to.
How do you do that?
You have. Sometimes what I'll do is I'll hire an attorney who has some more expertise and try to get a sense of A, what the nature of the suit is, B, what the damages are, C, what the likelihood of success is, and D, is it collectible or not? All of these go into factoring what that asset is really worth. But to get back to what you asked a few moments ago, sometimes if people have assets that are in excess of their exemptions, that doesn't necessarily mean they shouldn't file for bankruptcy relief. Because what trustees will do, and I can speak for this trustee, I can't speak for everybody, is if there's an asset that has some sort of value, there's something that I think of as sort of, let's make a deal. There might be an asset that has value, a non-exempt value of, I'll say, $10,000.
Yep.
Well, if I were to go sell that asset, whatever it is, at auction, I'm not going to get $10,000. I'm going to get something less than that, and I'm going to have to pay the auctioneer, and I'm going to have to go through the incur attorney's fees. So make me a proposal that gives me, for creditors, what equal to or what I would get by way of a sale. And with court approval, I may do that. And that way I get some money that gets distributed to creditors. And to use simple numbers, let's say there's an asset that I recover $7,000 for, and someone's getting a discharge of $80,000 of credit card debt. It's still a pretty good bargain for that person who's in bankruptcy, even though it's not a no-asset case. And that's part of the analysis. And on the other side of it, that's part of the analysis I do with my own clients. Say, look, your assets may not be fully exempt. You have to decide what to do about that.
Okay. I can't do the show and not ask, what do you say when somebody says, how is bankruptcy going to affect my credit report?
The short answer, or maybe the Weasley lawyer's answer, is I can't give them exact numbers, because the exact formulas are fairly closely guarded secret, apparently, from the credit industry.
Because FICO is a mystery to most people, right?
Yeah, including most lawyers, I think. But I try to answer the question in two ways. Number one is the credit record probably already looks pretty grim. If they've been delinquent on their mortgage, if they have large credit card debt that they're not paying, they're being sued, all of those things, the credit report may already look pretty bad, and a bankruptcy may not do it any more harm.
If they're really a candidate for bankruptcy, I think this speaks, not to interrupt you, but this speaks to the comment earlier that people who think people just file bankruptcy because they woke up that morning and thought, today's a good day to file bankruptcy, or it's some sort of strategy, haven't lived through a bankruptcy. Most people who file a bankruptcy are delinquent for so long, they just feel that they have no other option, and that's when desperation brings them, I think, to a bankruptcy attorney. Yeah,
and actually, it's true. I mean, and I can use a lot of analogies, but one that I think of is what I perform sometimes is economic root canal.
Right.
People, if they've got a bad tooth that's keeping them awake at night, night after night after night, and finally it gets bad enough where they, as much as they hate calling the dentist, they call the dentist and say the tooth has to go.
Ambisol isn't working anymore, right?
Yeah, and financial troubles are the same thing. It keeps people awake at night. They stress. They're taking phone calls. They're trying to hide the fact that they're getting phone calls on debt collection. And finally, the stress of dealing with all that becomes less than the stress of picking up the phone and calling a bankruptcy bankruptcy attorney and saying, I need to talk about getting some relief. And so because of that, I think of what I do as, I think there are three things I do. One is obviously legal. One is obviously economic, and the third is psychology, because people are, it's a stressful situation.
Yeah, we talk all the time about psychology of debt and things of that nature. Boy, there's an old saying that just came to mind, until the pain of the, until the pain of the solution outweighs the pain of the problem, nothing will change.
Yeah, and there's something to that. And
I think there is, yeah.
Yeah, and what I do is I try to, number one, give people as much information as I can about the process so they can make the decisions. And again, I don't have a psychology degree, so I don't charge them extra for the psychology, but if I'm successful at the end of the day, people will start sleeping better at night and being able to move on with their lives. And sometimes, even when I talk to them and say that they don't need a bankruptcy petition, that they may be able to try to work this out on their own, even that, just the fact that they know what the options are.
Yeah, something has been, they have a road to start to get some help. That is an important point that I have to talk about. When we see people at Power Down Debt, same thing. They come in, they're stressed. You know, now most of my people are making their payments on time, or they're very close and they can do it, and they're not usually a candidate for bankruptcy. But they feel such a sense of relief when there is a solution before them. We do a lot of retraining, and I'm sure that you must be saying the same thing in bankruptcy. It's nice that and I always warn them against this. When I do have to ship somebody off to file bankruptcy, I always say the same thing, although I think it gets lost in the timing. I always say, you know what, I know you're going to file a bankruptcy. I know you're going to breathe a sigh of relief. You're going to say, oh, this is better. I can make my payments now. But I want you to do something after that, and that is either come to Power Down Debt or get a counselor of your own or do whatever you can do so that you change what habits got you into that in the first place. Because although some bankruptcy cases just happen, you know, some awful thing happened to you in life, very often I see people in financial trouble because they spent above their means. They lived above their means, or they lived within their means, and then a job got pulled. And I want them to sort of retrain to live below their means and start to think about not doing everything on credit all the time. And that's why I asked you earlier, how often do people file bankruptcy more than once, you know?
Yeah, it's still a minority of people. It's not unusual, and especially with the economy over the last few years, when there have been so many people who have lost their jobs or have gone upside down on their houses as a result of the whole mortgage crisis, where they had to file a second time. But it's still the minority of people. I think for the majority of people, there's been one of 3 or 4 precipitating events. One is obviously job loss. A second is uninsured medical expenses. A third is divorce and divorce-related issues. And a fourth that I'm seeing more and more often is when one member of a household either quits a job or takes reduced hours to take care of an elderly family member. And some people, of course, have combinations of all of those. And once they can get through that, hopefully, and if they end up filing a bankruptcy petition, they usually are much more cautious about incurring debt going forward in the future.
We are almost out of time, so yes, it goes so fast. Maybe if you come back, maybe we'll do another show. I wanted to ask you about Homestead Act. Can you give me a 30-second snippet about Homestead Act?
Yeah, I'll try to do it in 30 seconds. The Homestead Act in Massachusetts is one of the great protectors for people who are filing for bankruptcy relief. In Massachusetts, the homestead exemption is $500,000 if you file a homestead declaration, and there's an automatic homestead declaration of $125,000 of equity in a house, even if you don't file. And in terms of filing, the statute changed in 2011, I think it was, to make it much more user-friendly. But for anybody who has a house, and especially here in Western Massachusetts, there are a few people in financial distress who have $500,000 of equity in a house. It is a great protector.
I agree.
So that at the end of the day, if someone's going to file for bankruptcy relief, and if they want to keep their house, the homestead declaration should protect all the equity in most houses.
Great. If somebody wants to get in touch with you, how do they reach you?
Well, they can call our firm, which is Shatz, Schwartz, and Fentin, PC in Springfield. We have our website, which is ssfpc.com.
So we don't have to spell it? Okay, and
that's
phone
exactly
number?
it. Phone number is 413-737-1131.
Thank you. Thanks for doing this.
My pleasure.
Thanks. Thanks for watching The Money Doctor. I'm Dr. Frances Rayam. Until our next chat, keep it positive.
There's a better life if I could be debt-free, but all my money is a mystery. I was feeling overwhelmed and it was wearing thin when I knocked on the door and heard the doctor's in. Oh, the doctor's in, the doctor's in. She got the right prescription to help you win. Oh, the doctor's in, the money doctor's in.